Okay, Oak Sparrow Properties and Sandy Property Management versus Chase Carson and Amanda Williams. Okay, today was the date set for hearing. This is for termination of tenancy. Did the parties come to a resolution?
We haven't spoken on this one, Your Honor. From the prior hearing, my understanding is we've got quite a dispute. I don't think that we're in dispute on possession. The tenants are indicating that they actually vacated far before we believe that they did. So I don't know. I don't think that a resolution is likely on this one, Your Honor. I do say that I will say the issue of possession is probably moot because the tenants are indicating moved out.
I don't know what prior hearing you're talking about. I have a note here. Let's see. You're saying you vacated the property?
Yes, Your Honor. I was served a 7-day on May 24th. I'm new to this whole process. I've always paid all my bills. So at that point, I uprooted everything that I could take, including my family, and we vacated the property. I attempted to make a phone call to Miss Sandy Bristol. Fell upon deaf ears, as many communications had to that point. I, at that point, thought this was all behind us, and then all of a
communication saying that you have vacated, is that what you mean?
Yes, I attempted to contact her and let her know the key was on the counter and we were out of there. No response.
You have record of where you...
I did text her and ask her why on the day of the that I received the 7-day, because at that point it was to my knowledge we were doing everything that we could to stay in the property, because we had previously had a case due over our animal that they tried to evict us and they lost in court, but for whatever reason that still shows up on our record. So when we attempted to go get a new home when they refused to renew our lease, we have a red flag. I can't rent anything. They won't even show me places. So I reached out to Miss Bristol, and in good faith I said I will do whatever it is in my power to keep my family in this home. I jumped through their hoops. I gave them record of my dogs. I obtained insurance.
I'm talking about this eviction, though?
What's that?
I'm talking about this eviction, not the previous one.
Yes.
Okay.
Yes, so, I'm sorry, I guess I misunderstood.
Okay, because I thought you were talking about there was another eviction about
there was
an
an
animal.
attempt at it. They were ruled against in the courtroom.
So since receiving this notice of eviction, that's when you reached out and said you would do anything?
Yes, after when I attempted to, because then we went back and finished out our lease, and then we got a letter in the mail that they are choosing not to renew. So I was like, that makes sense. And I attempted to find a place. When I realized we were blacklisted and I couldn't even rent a place, then I reached out to them and said, I'm willing to do anything that you would like. And I did everything they like. They walked the property. Everything looked good. There was no damage to the property. And then all of a sudden the letter comes in the mail, you need to leave within 7 days. So in fear of another thing going on my record, I took what we could and we vacated there. We were gone before June.
When you say you took what you could, doesn't sound like you took all your stuff.
No, ma'am. No, ma'am.
And then you didn't turn over possession.
Like I said,
what did you leave there?
I just things that we didn't have space to store or anything. I took the possessions, our day-to-day possessions, and we bounced around since. We were going to make an attempt to clean the place up if that was their request, but again, she did not give me any communication back and forth until we got a new court date.
So you communicated with her in via text after you left?
Yes, I asked her on the 24th. I said, why? And she says, you have continued to ignore us. You never submitted the animal application, and the dogs were an issue. It's too much of a liability.
Did you tell her that you vacated? Did you tell her that you vacated?
No, because I hadn't at that point. This was the day that I received the 7 days.
I want to know about you communicating that you vacated.
That was a telephone call.
Okay, you called her?
I don't have a record of the telephone call.
Did you talk to her on the phone? Or did she not answer?
No answer.
Did you leave a voicemail?
I was not able to leave a voicemail.
Why not?
To be honest, I don't know if her mailbox was full or what have you, but I wasn't able to leave her a message at that time.
Okay, so how was she supposed to know that you vacated?
Answer the call.
Okay. So when you called, let's say she was tied up and busy, couldn't answer. Or maybe technology didn't work well, and she didn't even know you called.
And I don't know how to answer that for you. It was a confusing, scary time for me. I have not experienced things like this. I just like I put my hands in there. We're out of here. Like I've done everything I can.
And you left the keys there? You said at the property? Okay, counsel.
I'm sorry, Your Honor.
Counsel, the property appears to have been vacated, but there was a number of things left there?
There was a substantial amount of things there left, Your Honor. From my understanding, the tenants continued to reside there because they were paying utilities there until the date of the hearing that I think Your Honor read, that was in front of Judge Buchanan. My client didn't get notice of the utility switch over. There was no indication of keys being left. There was no written notification. There was no verbal notification. Up until that hearing, we had no idea that they were going to even claim that they had moved out back in May.
Where were you still paying?
Well, we had past due amounts, so I was paying the minimums at that time to keep my name from getting to the point where I wouldn't be able to put utilities in my room at the next, or I mean my name at the next residence that we would be at.
My client didn't get notification of any utility turnover until, again, after the hearing that was looked at back in November.
Which all would have been communicated had her client answered the phone call, but she put me on
Well,
silent.
you didn't change the utilities over to your new place. Where did you? When you left,
I can't find a new place because.
Okay, so you don't have a new place.
No, I'm bouncing around, staying with my mother at the moment.
Okay.
This has created quite a situation.
But you didn't disconnect the utilities at the place. You just was paying about. You have some evidence of the utility bill.
No, I don't have evidence of the utility bill.
Do you have any evidence of what was left in the property?
I have a ton of videos and photographs, Your Honor. My client has also gone by the property several times and can indicate that the vehicle that Mr. Carson and Ms. Williams, that vehicle was outside of that property on many occasions when she was driven by. There's a ton of stuff outside of the property. There was absolutely no indication that these parties had vacated. There's shoes on the porch.
Show your evidence.
And Your Honor, I will say too that the client.
Was there any physical evidence of us being there, or a picture of my vehicle there? Because I can guarantee that wasn't the case. They park in the driveway next door.
Okay.
Well, how would you know where my client parked?
Well, if you all want to talk off the record, bye. You can talk outside if you want to talk to each other. If you want me to handle it, then you talk to me. You can talk outside. Next case.
Yep. Okay. Go! Will you hand me my screen box?
Now go preach. I'm back on the record, counsel. And this is Oak Sparrow versus Carson and Williams.
Thank you, Your Honor.
And you've not come to resolution, correct?
We have not. It sounds like we're at an impasse, Your Honor.
Okay, so then you need to talk to me and not to each other. Back and forth is not going to be allowed. If you start back and forth, I got to move on. Look, all these people behind you waiting for their turn.
Apologies, Your Honor.
Okay. I'll allow you to present your evidence.
At this point, Your Honor, it sounds like based on some of the claims that the tenants are going to make as far as the utilities and how those were paid, I'm not able to access that. My client is not able to access a record that is in the tenant's name without a subpoena. So I'd ask the court to allow me to issue a couple of discovery subpoenas and reset this matter.
You said about how the utilities were paid, you mean?
Yes. My understanding is that utilities remained in the tenant's name, that they were paying those regularly until that November hearing with Judge Buchanan. The tenants are now claiming that they were only making the minimum payments and they were paying past due amount. I'm unable to access those records. My clients have called and they've tried to get at them, but the utility companies obviously are not going to release an account in someone else's name. So I think that would be an essential piece of evidence in this case. And so I'm asking for the ability to issue subpoenas to Board of Water and Light and Consumers.
That's fine. Is the property secured and winterized?
My clients have gone into the property, Your Honor. I don't know if they have. I would like an order actually confirming the possession that they can retake it, because they have gotten a notice from the city that they've asked for an extension until Monday in order to remove trash that's from the property. Otherwise, they're going to give a violation.
So there's trash that you're saying that they left. Can I see?
Yes.
Your Honor, that's something I'm privy to as well.
Okay, so it's front porch. This is from the code enforcement. They said that there was trash found in boxes, bags, and barrels on front porch, clothing and cloth products on front porch, deteriorated metal product on front porch, loose trash and debris, front porch and yard, around and behind the house. Did you leave trash at the property?
Yes, you could consider it trash. Yes, there were several items that I explained that I had no choice but to leave behind. I didn't have.
No, you have a choice.
I did not.
You do have a
I had the
choice.
financial ability to do that.
Did you put the trash there?
I'm sorry?
Did you put the trash there?
There were items in the home.
Did you put the items, did you put the items that have accumulated causing code compliance to come and issue this concern violation about? Did you put it there?
On the porch, no.
So the things there are not yours. How did they get there?
I don't know. They've had the property.
Do you have
since May.
pictures?
I have some pictures of the exterior of the property, yes, Your Honor.
I can't say what they're.
I didn't ask you to speak right now. Do you have copies for him?
I handed him one.
Okay, I see a helmet, I see a, look like child's car, a welcome mat, or something, welcome thing. I don't know what
Again,
this is on the, I didn't ask you to speak over me.
Oh, I'm sorry.
It looks like something else on the porch, I don't know what it is.
To be boxes and shoes.
Is it boxes and what?
It looks to be 2 empty boxes and a pair of shoes.
What are the toys in the front yard?
Those were toys that my children played with outside that I have nowhere to store now. So they were items that were, yes, and left behind.
Okay, so there's shoes, there's boxes, I do see debris. You didn't put those there?
I'm sorry?
You're saying you didn't put these things there?
That's why I said, is it trash or what are the items so that I can specifically tell you? Like, I wouldn't consider my kids' toys trash, but to each their own opinion.
You left the things here?
Yes, Your Honor.
Then you think that they're supposed to be responsible?
This photo was taken while we still live there, by the way. That item is in our possession. That football helmet is currently in our possession. I don't know where these pictures were taken or when, but that time frame they just gave you is wrong. Actually, multiple items that are in these pictures are currently in my possession.
Could I ask him to confirm what date he's going to say that he moved out?
What date did you move out of the property?
It would have been May 30th and 31st.
My client took these photographs at the end of June.
Any other evidence that you have today?
I have a witness with me, Your Honor.
Take this in.
Okay.
Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Thank you.
You can have a seat.
Ma'am, can you state your first and last name and spell your last name for the record?
Jennifer Willcutt, WILLCUTT.
And are you a representative of Oak Sparrow Properties?
I am.
Are you employed by Sandy's Property Management?
I was in 2024, yes.
Thank you. And are you familiar with the file for Chase Carson and Amanda Williams?
I am.
Have you, and they've lived at 1317 West Shiawassee Street?
Correct.
Have you, since May of 2024, have you been to that property?
Yes.
More than once?
I drove by the property at least once a month from June until November 20th was the last time because I was told that they had told the court they had taken.
And that's all through 2024?
Yes.
And did you observe any changes in the property between May and November?
Yes.
Did items appear to be moved?
Yes.
Did it appear to you that there was somebody residing in the home?
Yes.
Are you familiar with the vehicle driven by either Chase Carson or Amanda Williams?
I've seen Chase put dog into I think it was a white kind of work type van possibly, or a panel. It was, yes.
So you would recognize their vehicle?
I recognized it on the street, yes. I wouldn't recognize it out in traffic.
Fair enough. When on these occasions that you've described driving by the property, did you observe that vehicle?
Once or twice in the street, yes.
And that was a vehicle that you had seen Mr. Carson access?
Yes.
At any point in time over the summer of 2024, did you get any notification from the city regarding any unkept lawns?
No.
Was that an indication to you that the lawn had been kept appropriate for the city? Sure. I'm sorry? You said something, sir?
Do I need to?
I thought he was interjecting. I'm sorry, Your Honor. Okay. Are you familiar, have you been in contact with the utility company in regards to 1317?
Yes.
And at any point in time, have you received notification that the utilities are being transferred into Oak Sparrow's name?
No.
What is your understanding of the status of the utilities?
On November 20th, 2024, there was no water or electrical service. I called Lansing Board of Water and Light at that time, and they told me that services were turned off on November 18th, 2024. I called Consumer Energy on November 20th, 2024, and they told me that gas service was still in Tenant'S name as of November 20th, 2024. I later went back to make sure that the property was still secure on December 5th, 2024, at which point there was no gas service. I called consumers and they said that it had finally been turned off in Tenant'S name on December 3rd, 2024.
And you said you appeared at the property on November 20th initially, and then
Yes.
again on December 5th. Thank you. How did you gain access to the property on November 20th?
I was told that they had stated that the tenants had stated in court that they had vacated the property, and I was asked by my superior at the time to secure the property. So I asked maintenance to please schedule a time to go over and get the locks open so that we could change locks and secure the property properly. No items were touched or removed.
When you appeared on December 5th, did you notice any differences in the property?
The door was open, and it looked like to be some kind of snacks or something on the stairwell in the living room. Things had been moved around a little bit, and that was about it.
Can you just?
Oh, the garage door was also. We had secured the garage door, and that had been opened up as well, and it was like items that were moved around in the garage.
The photographs that have been presented to the court for the outside of the property, is that fairly representative of how the interior of the property was kept as well?
The interior has a lot more trash and items left out than the exterior. The exterior is not the worst.
Can you give a general description of the interior of the property?
There's a large mirror in the middle of the kitchen. There's trash bags that the mice have now taken over. There were baby and children's toys in the living room. I think some type of small animal bedding, a bag of animal bedding was in the living room. And then there was just general personal property throughout, clothing items, shoes, children's toys.
Were you able to speak with any of the neighbors who live nearby at 1317?
Yes.
And did they give an indication of observing the Mr. Carson and Ms. Williams there?
It's hearsay.
At any point in time, have either Mr. Carson or Ms. Williams indicated to you or to your knowledge, have they said that they were moving out?
No.
In April, did they indicate that they wanted to renew their lease?
Yeah.
Were you working on actively renewing the lease?
We were actively working on a month-to-month agreement.
What's your objection?
That is not the truth.
Objections are for evidentiary foundation, not that you dispute what she's saying. So if you dispute what she's saying, when she's finished, I'll give you an opportunity to give your testimony, but that's not an objection.
Okay.
So you can continue, ma'am.
Thank you. Did Mr. I want to call him the Carsons. Did Mr. Carson or Ms. Williams turn in their keys at any point?
No, not to my knowledge.
Did you ever receive any written notification that they were terminating their lease?
No,
Did you actually appear at the property on May 1st of 2024?
I did.
What was the purpose of that appearance?
To inspect the home to see if there was any animal damage and to give animal applications and to explain what paperwork the owners have requested in order for them to stay in the property with their.
And so that was part of a process of extending the lease.
Correct. Mr. Carson also provided me with documentation for the dog licenses and vet records, which I did copy for him and returned on May 7th. I did not enter the property on May 7th.
After May 2nd, did Mr. Carson ever indicate to you anything different other than moving forward with renewal of the lease?
No.
Are there any other facts or details that you think would be relevant to the court as far as this matter and whether the Carsons moved out in May?
The picture with the football helmet that was brought up, I took that personally, and that was on June 27th. The trash bin was also at the curb. On November 20th, the trash bin was in the backyard by the garage.
Any other details that you recall of items being moved around or?
There's a small child's car, I believe it's green. When the picture on the front, I think, shows it in front of the stairs, that on November 20th, that was moved into the fence area. It was,
And the helmet's missing.
and the helmet wasn't seen.
And then, had the tenants paid any rent between May and November of 2024?
I believe their last payment was May 2024, mid-May.
Do you recall offhand the unpaid balance that's owed to the tenants?
I do.
If I showed you a copy of the ledger, would that refresh your recollection?
Yes, it was.
Go ahead and take a look at that. Don't testify from it, but when you read it, go ahead and look over. Okay. Do you recall the amount that's unpaid rent for the tenants?
$9,900.
Thank you. I don't think I have anything further.
Do you have any questions for this witness?
So you say that you've gone by once a month at least to check on the property.
Yeah.
And you've seen a vehicle that you believe to be mine there, correct?
A few times, yes.
And what was that vehicle?
I think it's a white van or some type of panel that has doors on the back.
Your Honor, I have no white van. I do not own a white van.
Okay,
I've never.
this is
owned
time
a
for
van.
you to give, or ask her questions, not time for
Oh,
argument.
okay.
Okay.
Sorry. Yeah, that. And are you familiar? You said you were familiar with neighbors then.
I did not say I'm familiar with the neighbors.
Okay. Are you aware that they have children there?
I did not.
Okay. And are you aware that children will play with toys if they see them, such as a power wheel left outside that could move a couple times?
Objection
Because
calls for
kids-
speculation.
Just saying that the neighbors next door, Your Honor, they have several.
The question
children
is
that
it
play with
possible,
toys.
is it possible that the neighbors?
Yes.
Yeah.
Is it possible that someone else?
No, I'm asking you, was that your question?
Yes, Your Honor. I'm asking, is it possible that someone else may have moved a toy outside the home? That's
Oh.
what you're going on
Instructions
for us to
overruled,
be
you
there?
can answer it.
I guess anything's possible.
Okay. And any of the times that you have drove by the home, did you physically see myself or any member of my family? Okay. And when you called to ask about the utilities, they wouldn't speak to you, correct, about how it works. So it's a good possibility that we were paying the minimums to keep our
Objection,
name from
argument.
getting.
Well, that
And
will
that's
cause
speculation.
speculation. That causes speculation, you don't have to answer that.
Okay. Well, my point, Your Honor, is that in order to get something taken out of your name, you have to pay it in full. This came out of nowhere. I had no means to pay it in full. That explains why the utilities were continued to get paid and stayed in our name right up until the point where they just shut them off. It wasn't turned off because we.
I
didn't
understand
want them.
you've cleared that with me,
Okay.
as part of why you've made those payments. They're asking for it to continue so that they can get the records. I'm just getting their testimony now, so when we come back, we don't have to do that.
I understand.
Do you have questions? Any more questions?
Not for her, no.
Okay, thank you. Any regret?
Why do you believe that Mr. Carson has ownership of a white van?
I have seen him putting 2 dogs in that van on May 1st. About 5 minutes before our agreed upon appointment, where Sandy, Dave, Bristol, and myself toured the property and spoke with both tenants.
So whether he owned it or not, he certainly had access to it.
He had keys that unlocked, and he opened the door and put 2 dogs in.
No further questions.
You said you had video, or is this what you're talking about?
The video, Your Honor, was taken by another witness who
Okay.
is out of the state at the moment. So if we do come back, I can present that, Your Honor, and have to testify.
Okay, sounds good. I'm going to give you this evidence back for now. You had an issue about the property. You wanted an order?
Thank you, Your Honor. I'd like an order for immediate possession and reserve the money judgment for a continued date.
Well, order for possession is granted. They said they've already turned over possession
That's never been
of
a
the
question.
property. We'll deal with the money judgment. We'll continue for the money judgment issue. And
Right.
obviously, if they have to clean up trash and debris, that goes towards their money judgment claim. You do understand that, correct?
What's that?
If they have to go into the property to clear out the trash and debris, that costs money. And so that's also evidence that will go towards the money judgment. You
And
understand
now, I don't know if it's possible or anything, but I would have had no problem communicating that with her, that I would be willing to take care of those items and get the property up to
No,
par.
you just told me earlier that you had no choice.
So I didn't have the means that within 7 days, but then I could say
No,
I
but
can come back with a truck when I can afford
It's
it.
been 6 months since
Yeah,
you
it was
said you left.
Yeah, and I just assumed they wrote it all off. That's why we're here today.
You could notice when that they
And
filed
I
an
also,
eviction.
go ahead.
They've been on notice of this for several months, Your Honor.
You couldn't have assumed there's been an eviction pending, so you knew that the eviction was still
Is it
pending.
general practice for them to drill out the locks and give themselves back the property without a judgment from the court?
It's not general
Okay,
course,
'cause that has
however,
happened.
it's also not general course to leave a property. That's why I asked, was the property secured and was it winterized? Because if you vacated a property, if I take what you say to be truthful, that you vacated a property in May and that you called one time, no one answered, you left no voicemail, you never followed, do not talk while I'm talking. You left no voicemail, you never followed up. You never got any word to make sure they knew that the property was vacant. That means you left the property exposed and any animal, creature, person could come and take over this unit because you just left it abandoned with things there. When you leave things there, they don't know off the top that you have moved it or rendered possession unless you notify them. And this is if I'm taking what you say to be true. And then on top of that, there's still electricity going to this. So if they check the electricity, they see that's still going on. So there's no reason for them to believe that you vacated unless you have communicated to them that you have vacated. It is now the dead of winter. We're in the middle of a snowstorm. It's going to be 0 degrees. That's why I asked, was the property winterized? Because if it wasn't winterized and those pipes freeze and burst and there's damage to the property and I make a ruling that you have not properly turned over the possession, then now you're responsible for the damage if pipes freeze too. Do you understand how that works? Okay, so what is it that you feel like so urgent that you need to share with me?
I was just wondering, am I the only one that's responsible for communication? They had any questions they couldn't have reached out at any point during this? Do they have any attempts to reach out to me or any of my people to resolve it?
They did reach out to you.
Other than court?
They filed a notice to quit and vacate, and then they filed a summons and complaint to bring you to court. They have communicated.
So-
If you have vacated the property, your responsibility is to let them know that you have vacated and turn over the key.
Should they choose not to accept my calls?
You didn't. You testified one call. That was your testimony.
Yes, I'm aware.
You already have enough for possession. You didn't turn over.
I'm not questioning.
Yeah, you
possession.
didn't
I'm
turn
just saying they
over.
took it
You
without
did
me
not
saying
turn
so.
over possession reasonably. It's not.
I just was
that's
under
not
the impression
reasonable.
They took it unlawfully.
Well, you left.
There was never a judgment for them to go in and drill out the locks.
You mean?
And give them
Oh,
access.
when did they do that?
I have no idea.
So how do you know they did that?
Because I went there after our last court date when I was realized that they thought we were still there.
After the last court date when you told me you had vacated in May.
Yes, I vacated in May.
So you're saying in May they drilled out the property and changed the locks?
I have no idea what their time frame for lock drilling was. I
No.
know in November when
You
I
went in
went there,
November.
the locks were drilled out.
After you've already communicated that
when I
you had.
found out that they thought
After
we
you
weren't
had
there.
already communicated that you didn't live there.
Yes. Because
So then
at
what's the
that
issue?
point they thought the property was still mine.
No,
As
at that
far as
point
that's
it's the
concerned.
middle of the winter
They're
and you
still
claim you left.
charging me for it.
In the middle of the winter, you claim that you left, and you left all your stuff there.
No, I didn't claim.
And you said
I
that it's
left in
not your
the winter. I told
responsibility to
you
get it
May,
out.
Not the winter.
Judgment for the plaintiff
For possession or money?
and money.
Thank you, Your Honor. Can I include standard costs in that?
Absolutely.
Thank you, Your Honor.
Thank
I'll
you.
get that submitted on e-filing.
Can I
Thank
object? I mean, can I like?
You can object all you want. I'm done. Thank you.
We weren't even there. They're getting this.
Do you want me to have you escorted out?
Oh,
Excuse me? You want contempt next? Because I can give you 93 days in jail. The record in the matter of Todd Doward versus Gerald Littlejohn and Kimberly Fish for -06938. Here, please.
Todd Doward, please.
Sorry, 86242 on behalf of the defendants, Your Honor.
Date that was set for a hearing This is for non-payment of rent. My understanding is the parties were not able to come to resolution, correct? Okay. Mr. Joward, you can explain.
Your Honor, no rent has been paid for 6 months. Not 1 cent. There was a judgment from August 21st of 24 for 907.28. That was paid on September 3rd, but no rent, not $1 has been paid for 6 months. I have communicated with the tenants every week or two. I have all the texts, and I brought them for a whole year. Not once have they asked for any repairs. They stopped corresponding back with me in like September or October. But so I have every text, every communication we've had.
So in September, you're saying you were communicating with them and they stopped responding?
That's when they stopped responding. I've been communicating with them every week or two for the past 6 months. What I have printed off is a text that I had between the two of us for the past year.
Oh.
Nothing about any maintenance. When I spoke with the attorney yesterday, he called me and says, oh, you know that the tenants don't have any heat, they're using space heaters. No, I do not know that. That has not been said to me. The house could burn down if they're using space heaters. So that's simply untrue.
They don't have heat, why?
I don't know. That's what the attorney said. Yeah.
Okay, so you were first informed, you were saying yesterday, of the lack of heat in the units.
The day before court, 6 months
Okay.
ago. Right. The last time that the tenants communicated with maintenance was 2 years ago. It was February of 23. So we've had nothing from them. The house is a licensed rental property. I have the ledger here. I have a copy of the text if the court wants to see them. I have a prepared judgment.
How much is their monthly rent?
The monthly rent is $1,300 per month. So the total rent with late fees for the 6 months is $7,900. The court fees $167.28 for a total of $8,067.28. I have the money judgment prorated to today's date as well.
Any other testimony or information at this time?
Not at this time.
Mr. Tyler? I don't need anyone that you want to call. You gotta call who you want.
I would love to call Ms. Christensen.
Thank you. Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Yes. You can have a seat there. I need you to speak up loud and clear because the lady behind you has to be able to take down everything that's being stated on the record, and then I have to be able to hear you over this, okay? Thank you. You can proceed, counsel.
Thanks, Clish. Would you please state your name for the record?
Kimberly Fish,
How do you know the plaintiff?
he's my landlord.
You're your landlord. Okay. When did you move to the property over there at Lakewood, Lansing?
I believe it was 2018.
Okay. And who has lived at that address with you?
Myself, my fiance, my daughter, and my son lived there when we first moved in. They now have their own place.
Okay. So currently it's just you and your partner?
Yes.
Okay. Did you sign a lease?
Yes, I did.
Was it a lease for a year or was it a lease for month to month?
It was a 12-month lease.
Okay. And what's the arrangement now? Are you guys month to month or still a lease?
I haven't signed another lease.
Okay. So it's month to month. What was the agreed upon rental amount? What did you guys agree to?
It was $895 a month.
Okay. And what is the most recent rent you guys have paid?
$1,200.
$1,200 a month. I believe the complaint says $1,200 a month as well. Does it not?
Yeah.
When was the last time you guys did pay them?
We were in court the last time we went to court, which was in August, I believe. And we had a judgment.
And you guys paid. And from my recollection, it looks like you guys made that payment indeed on September 4th,
Yes.
which you brought current with
Yeah.
that payment. Did you ever have any discussions with landlord's agent, his son, about the fixes that need to be made over the 9 years, 8, 9 years you guys have lived with the property?
Yes, I have.
Okay. It could have been maybe potentially longer than of a 1 year birth. Was there a reason you may have stopped making those connections or reaching out?
Well, when I addressed it to Todd over the phone, he told me I had to contact his son, Brad.
Okay.
In which I did.
And then what happened after you contacted Brad?
He was going to come out, and that was 2 years ago when my grandson was born. And I told him he could still come or he could wait. He said, I can come tomorrow, I'll be free. And he never showed up.
What was he coming for?
To fix the furnace.
Okay.
So just to reiterate, you did put Mr. Dowrick on notice about the furnace 2 years ago. He told you his son would contact you. Son contacted you. There was a mishap in maybe trying to get together
Yes.
to get the fix made, and then it never was in follow-up, correct?
Yes.
Okay. So are you guys currently still without you?
Yes.
Okay. Have there been any other maintenance issues with the property?
Yes.
Could you name some of them for me?
We had the city inspection within the first 3 years we lived there. And the lady had come up with a list of things that needed to be fixed, including the gas hookup for the dryer to downstairs. The faucets were corroded under the sinks. There was just a list of things they needed to come and fix. And they never came out and fixed them. She came again 3 years later because we've been there for a while, and she wrote it off as fine.
Okay.
You said she wrote it off as fine, you said?
Like there was not an issue, but they never came and fixed the issues from the first.
Did you guys ever have to deal with any mold, any cleanliness, anything that you guys told them? Could you explain that to me? Also,
Yeah.
could you say yes, because
Yes.
the reporter can't hear
I
you.
currently have mold in my basement and under the sink in my bathroom. I can't keep anything down there.
When you say you can't keep anything down there, could you tell me why?
It just
how
gets moldy.
it gets moldy.
I just
The mold.
usually just spray like mold
Okay.
stuff down there and keep it shut.
Did you ever let your landlord know about that issue?
The city inspector had said something. That and the fan in my bathroom.
You heard Mr. Dowrick, he claims that you guys haven't made any payments and that you just went radio silence on him. Is there a reason? Could you help me, I guess, better understand why you may have stopped communication with that person?
Well, after the last judgment, it wasn't, but maybe a couple days later where he started messaging about October. And we've had our electricity shut off a few times because our bill is through the roof, running space heaters, trying to keep the house warm. In the areas that we are, we obviously can't keep the whole house out with space heaters.
Okay.
So it's just been paying it. We have money for rent, but then we have to go pay water and light, a deposit and all that to get it turned back on because it got shut off. It just makes the bills a lot higher than what they should be.
Is this the first time the furnace has gone out, or how long has it been out? Just again,
The minimum 3 years.
a minimum 3 years.
It was not working properly before that, and his son did come out and said we needed to change the filter. And we changed the filter quite a few times. We even bought extra filters, and it would kick on. He says it works. He leaves, it kicks on.
So for 3 years, you guys have had to go without.
No heat at all. Yeah.
Okay. Minus the space heaters and skyrocketed electric bills.
Yes.
Such. Okay. No further questions for this witness, Your Honor.
Do you have any questions?
Yes, Ms. Klish. You say the rent is currently $1,200.
Could I show you this letter where the rent was increased to 1,300?
Well, you have to ask her a question.
Okay.
Maybe ask her, does she remember the rent being increased to 1,300?
Do you remember a letter I sent to you on September 25th of 24, stating that effective November 1st of 24, your rent is increased to $1,300 per month? Are you familiar with this letter?
Well, without showing her, see if she remembers. If she don't, then without showing her.
I don't.
No.
Without showing her.
And
Okay.
if she doesn't remember, then I'll allow you to refresh her
Okay.
recollection.
Thank you.
I don't remember the letter.
I'd like to show it to you. That's okay.
Does that refresh your recollection?
No.
Okay.
So you're saying you didn't see this letter? I have my copy of it.
I can't say that I received the letter.
All right. I mentioned text. I have a copy of the last year between you and me. There is no request for any maintenance
Is there a question?
whatsoever. Why, if you had an issue with a furnace or something else, why would a whole year of text go by without you asking for a repair to be done?
Because you told me I had to contact Brad for that, your son.
You mean, so you're going without heat. I want to understand this. You're going without heat for 3 years. This is a licensed rental property with a valid certificate with the city of Lansing, and you're not demanding that the heat be fixed?
I have demanded that the heat be fixed, but you told me that I have to contact Brad as the maintenance, that you don't deal with that kind of stuff. And like I said, the city of Lansing inspection, it can't even be, I don't even feel it's credible because it was the same lady that came 3 years before that year. And she wrote up a list of things that needed to be fixed, and you or your son never came. And then 3 years later came and passed everything. So if the same lady said that these things were damaged, and then 3 years later nothing was fixed and she said they're fine, I don't find that credible at all.
I have in front of me the certificate of compliance for rental dwelling. And the property, it shows that the property was inspected on July 14th of 22. It gets inspected again next month. Do you recall this inspection?
I do. I was there both times she came, both years.
Do you recall the list of things that we were asked to do by the inspector?
I followed her for a little bit. She said the gas hookup downstairs was faulty for the washer and dryer connection. And she said that the fan in the bathroom needed to be fixed because it wasn't working properly. There was some smoke detector issues that was fixed that day. And there was corroding on the faucets and underneath the sinks. Those are just the ones I remember.
So the list, I have the list here. It's signed that everything was completed. So you're saying that these items were not done.
I'm absolutely saying neither you or your son came and fixed anything after the first inspection.
So we lied when we signed the form and said everything was done.
Obviously, if that's what you're saying, then that's what you did. But I know 100% that neither you or your son came and repaired anything. And that was what was confusing because the same exact lady came 3 years later and passed it 3 years later and nothing had been fixed. That's when I started to wonder what's going on. Do you guys have a personal relationship, or because how can it be faulty and nothing's fixed and like 3 years later it's fine?
Did you call the city of Lansing and say, hey, I got problems with this house? They would come out and inspect it. Yeah.
I did not.
Sorry, Your Honor, I'm hard pressed to find why it's her responsibility.
But it's not an objection.
Sorry,
Well, it's got to be an evidentiary objection. It's irrelevant.
I know.
It goes to our credibility if that was your objection.
I have the text messages between you and Brad Dowrick. Brad Dowrick heads up the maintenance. All maintenance requests have to be in writing. The last time we communicated with Brad Dowrick was 2 years ago, February of 23. If you're having maintenance issues, why are you waiting 2 years without asking for one thing to be fixed?
He said it was a filter issue. He did come. He said we needed to buy new filters. I, at one point, had a conversation with you about maybe the ducts, because there's a lot of dust in my house, like when you turn on try to turn on the heat, the fan, anything. And I've even used my vacuum cleaner to try to get down in the ducts and suck some of that out. And I had that conversation with you years ago. And you said you were not going to pay somebody to come and clean out the ducts. And I said, maybe that's why the furnace is cutting off, because I don't know. I mean, I'm not a repair. I don't repair furnaces. I really don't know what's wrong with it, but I do know that it does not work.
I have a question. I need some clarity. You're saying you've been without heat for how many years straight?
At least 3.
When's the last time you text? I didn't ask the question yet. When's the last time you contacted Mr. Dowrick or his son Brad Dowrick for maintenance on your furnace?
The last time I texted him,
Communicated with him.
the last time, I can't say an exact date. It wasn't within the last year, because I've had conversations with Todd, like after court, or when he's been trying to get money judgments, and I've explained, like, we don't even have, heat doesn't work, we're paying high bills for electric, but I never knew until just now that maintenance request had to be written. He just always told me to call his son.
Okay, but you're saying you haven't communicated with either of them within the last year about the furnace?
Correct.
Okay.
Why
are we here then?
I'm sorry?
Well, then why are we here?
I don't know.
If your client hasn't communicated about an issue, how is he supposed to be? And there was a judgment. When was that for a non-payment of rent, or?
It was for non-payment rent on August 21st. That was paid off.
For what, August of last year?
August of 24.
So there was a court case last year and this wasn't an issue then?
No, it was not.
Okay, so there was a judgment, and then nothing brought up then about condition of the property. Now we're here, rent still not being paid, and then no record of communicating even since that judgment or in the year of that judgment of an issue with the property. Why are we here?
She didn't communicate with them because her communications thus far have fallen on deaf ears.
That's not what she just said under oath. Under oath, I asked her, when's the last time? She said, not within the last year.
I mean, prior to this last year, Your Honor, I do apologize. My understanding is that from at least 3 years ago, she's been trying to get this furnace fixed. I would too stop asking to get it fixed if a year.
I wouldn't live with a house with no heat
I agree.
and expect to be there and pay a high bill. I would move. I would call the city.
Mhm.
I would do a number of things. I can't put myself in her position. I can only ask, I can only follow what the law dictates. And that is, if you're going to be in a property as a condition, and you want to use that as a reason why you didn't pay your rent, there's certain things you have to do to show good faith. Number one, you got to put your rent in escrow. Was there rent escrow?
No, it was not.
And number two, you got to notify the person that there was an issue. It can't be, well, I told them 3 years ago that there was an issue. She said that he came out there and changed the filter. Well, what do you tell him since then? I need some record of some communication. And if I got record, I haven't reviewed his text messages yet. If I review these text messages and I see where he's communicating with her regularly, asking for his rent, and there's never a response that says, sir, you have not fixed our heat, then it doesn't sound like good faith here.
I believe that at least for August, the rent wouldn't have been, or the heat wouldn't have been an issue because it's August. I don't know when or if they've ever had any other.
He said he's got a year worth of text messages there. Is that
He has
correct?
A year worth of text messages.
I have a year worth of
Just-
text messages, no request for any repairs whatsoever.
You reviewed those text messages?
I have not seen those text messages.
Well, before I gotta see him, he's gotta see him. We'll go off the record so you all can review that, because I'm not 100% sure why we're here right now. It sounds like something that needs to be resolved. Because if I make a ruling, that someone's gonna be upset.
Would you like us?
You can step off the stand for now. We're off the record, because I can't review those messages if your attorney has not reviewed them. And then we'll, once you review them, we'll see if he wants to admit them as an actual exhibit, which he's not formally asked, but it looks like that's what he's trying to do.
Yes, ma'am. Would you like us to take-
Yep, you can step off and then I'll call the next case. I'll call you when you're ready.
Take one.
Thank you. On the record, back on the record in the matter of Dowrick versus Little John and Clish. Okay, counsel, you had opportunity to review the text messages. I'm assuming he's making a motion to have these admitted as exhibits.
Yes, I am.
Any objection?
No, your only objection, not objection, personal, I guess, point of contention. I don't think text messages are going to communicate. My clients are kind of big.
Well, I asked her under oath. She said she did not communicate with them about it for a year, so that's, I asked her, I didn't, I said communicate.
I'm aware.
I said, when was the last time that you communicated with him about the furnace? She said, not within the last year.
She was under the assumption that we were still talking about text.
She was not, because I clarified it on the record.
Right.
I said, she said text message, I said, no, communicate.
Yeah, no.
Okay. Did you have any other witnesses? I need to see the text messages, please. Is there any photographic evidence of these conditions on the property, the alleging mold, something to show me that the thermostat didn't change when the heat was turned on?
No,
Any
my
evidence?
client is letting me phone and all that stuff not transferred over, so. Do apologize.
But the person, you still live in the house, correct?
Yes,
You have a phone?
I do.
I don't see how that works. And they could do that this morning.
I wasn't aware that it was gonna be like a full trial. Usually we go to court and then they set a date for a trial or.
We do that already.
It got
You had a
postponed.
pre-trial.
No, that's.
Okay. This is very simple. You have a non-payment of rent. You have a copy of, I think the issue that's not so simple is how much the rent was. I think we understand, at least at one point, it was $1,200. But you're claiming that there was a letter that was sent to them. How was it sent?
It was sent by US mail. I have my copy. It's a carbon. I have my carbon copy of the letter.
You sent when?
It was sent on September 25th, 24, stating that effective November 1st of 24, your rent is increased to $1,300 per month. The ledger reflects $1,300 effective November 1st. Would the court like to see the ledger?
All right. So I have your text messages, and I'm looking at the pattern and how you started telling her every time. Well, you've been consistently telling them every time, or her at least, every time the rent was due and what she owed. And I see when it shifted to $1,300 increments. I don't see any response that, hey, that's not how much my rent is due. I don't see any response. Primarily, the reason why I have a concern about the credibility of your witness's testimony is because it's unreasonable for me to believe that for 3 years you live in a home where you're paying $900 to $1,200 a month and you have no heat, and there's not a single text message when I have a year's worth of very active communication and you don't mention I don't have any heat. At one point she stated she didn't even have Brad's number. Well, if you're communicating with him about maintenance issues, you would have his number. So she wasn't communicating with Brad because she said in the text message she didn't have his number. Not only that, there was another eviction within the last year and a judgment where this was not an issue. Rent, it looks like from January of 2024, which is what the messages I have, there's constant and continuous text messages being sent to the tenants about the rent that is owed. There's not, responses are always, my mistake, you're right, I'm gonna give you the payment, I'm gonna give the payment to Brad, then I don't have Brad's number. I mean, there's communication about your rent's due, and there's a communication about the condition of her vehicle. She's got a nail in her tire, or her fiance or boyfriend, whoever it is that's living with her, is laid off, or her truck has a flat, or she's not working, and he wants to know if she's still working for Matt and Heather. Her goddaughter is in the hospital. So if my landlord is not providing me heat, and he's texting me about my rent, I ain't talking about my 3-year-old goddaughter being in the hospital. I'm talking about where's my heat. Unreasonable. You're not going to tell me, and then it's absolutely her responsibility to call the city if she believes that the furnace is not working and the landlord is ignoring her request for heat. She never made a request for heat. That's the problem. She's been living in this house. There's no record, no evidence of any mold being brought before this court today. You knew you was coming to court. The evidence should have came with you. You knew you were alleging that there was no heat. There should have been some evidence. And look, Your Honor, here's a picture of my thermostat. My heat is running and it's not going up. You brought me nothing. You didn't even bring me proof of your electric bill to show me that it went up because of the fact that you've been running space heaters throughout a house to heat it. So you've not met any burden to show me, to make me believe anything to support your claim. To the contrary, the text messages make me believe that it wasn't an issue, because you would be talking about that other than all the other things. Then what's really important to note is that after September 23rd, there's a text message in there. She's responded to every single text message about past due rent, and she's never on time. It's never happened. And then September 23rd, he tells her, I'm filing an eviction tomorrow if it's not paid. She said, I can drop something off tomorrow. And then she now brings up another issue about her car. Well, then we go into October. She goes silent. She says nothing. She didn't come to the court and escrow her rent and file a notice saying that I need you to force my landlord to give me heat. Nothing to operate or show operation in good faith. So for those reasons, I don't believe you have a lawful claim to withhold the rent. So judgment is in favor of the plaintiff in this matter.
Prepare the judgment if you'd like it.
Yes. It's judgment in the amount of $7,900 for past due rent plus $167.28 for court costs, for a total amount due $8,067.28. He'll pay that in full or vacate the property by the 24th of this month. There's also money judgment that will enter in the amount of $7,157.14 plus court costs. Grand total of the money judgment, $7,324. We'll get you a copy of that in just a moment. Any additional matters for the record?
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. People going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
No patience for that. And trust me, after the day, I'm sitting up here, I'm the one that needs a drink.